Welcome to HR ListenIn, the free monthly podcast from the employment team at international law firm Taylor Vinters. We hope you enjoy the show. Hello and welcome to the November 2015 episode of HR ListenIn. I'm Dom Holmes, an employment lawyer in Taylor Vinters' London office and presenter of HR ListenIn. Now, the employment team here specialises in providing strategic HR advice to clients, particularly when it comes to maintaining a flexible workforce to meet both short and long-term business requirements. In our experience, it's pretty rare for an organisation to have precisely the right number of employees with the perfect mix of skills and experience and all of them working at full capacity, whilst not being overworked, of course. Fluctuating customer demands, external market forces and internal resourcing issues all contribute to the constant balancing act of maintaining a motivated, financially viable workforce and simply getting things done. It's a conundrum we covered off recently in our HR forum, which we ran in both London and Cambridge, and we received some really interesting input from delegates, so we thought it would be worth summarising some of those discussion points for our wider group of podcast listeners. And to help me do that, I'm joined again by my employment team colleague, Scott Glacken. Welcome, Scott.
Thanks, Dom, and hi, everyone. Yes, I think that flexible workforce management is a really crucial topic for HR, both in a day-to-day operational sense and in helping a business to formulate a longer-term strategy to grow and respond to market challenges.
And to be clear, Scott, we're not talking here about flexible working as we normally understand it in the kind of family-friendly sense. It's a much wider concept than that.
Yes, that's right. It's a broad subject which encompasses any flexibility in how people do their jobs to best fit in with what the business needs from them. So it could include, for example, changing duties to fill a gap left by a departing employee, changing line manager or job title, introducing new working practices such as a new accounting system or safety protocol, changing hours or shift patterns, a temporary or permanent change in job location, increased travel requirements, amending or withdrawing benefits or capping large bonuses, or reallocating work. So this could be for a variety of reasons, perhaps because a work colleague is off on sickness leave or family leave, or to relieve pressure on other employees who are overloaded, or even at the request of the customer.
So that's quite a long list there, Scott, and a lot of these need to be managed and messaged quite carefully. They can be quite sensitive subjects.
Yes, the most contentious changes tend to be those which either have an impact on an employee's status in the workplace or on their life outside of work. So, for example, those which may disrupt childcare arrangements or work-life balance.
Well, I think at the time available we should focus briefly on two important areas. Firstly, to what extent can an employer take unilateral decisions to put in place the next necessary flexibility based on what is in the employment contract? And secondly, if the employment contract does not contain that necessary scope, how does the employer go about introducing changes to the contract to give that flexibility?
Okay, so we have asked whether the contract allows an employer to take a unilateral decision to make changes to fit in with business requirements. If the answer is no, or possibly but it's too risky, what can an employer do?
Well, Scott, there are three options with varying degrees of risk, I would say, and I'll list them in order of attractiveness. So, first, you can seek the employee's consent to the proposed change, and this is almost always the best way to go about things. It will normally require some element of consultation to get the employee's buy-in to the proposal, which should then be documented as a formal variation to the employment contract. Secondly, if you cannot obtain the employee's consent, you can seek to dismiss the employee on notice and offer to re-engage them on the proposed new terms. Now, this is quite risky, but it is sometimes the only realistic option if there is a genuine business need to make changes and the employee refuses to consent. And number three, you can simply seek to force the changes through in any event, even where you do not have the right to do so.
And I guess that third option is never the right one to use.
I would say almost never the right one, Scott, correct. I mean, for a start, it is a breach of contract, and if it is a fundamental breach of an existing term, or if it destroys trust and confidence, as we've discussed, the employee can resign and claim constructive dismissal. If they have more than 2 years' service, there is an unfair dismissal claim there, and it will also mean that any termination, post-termination contractual obligations, for example, So things like confidentiality or non-compete restrictions will also fall away.
But of course, for an employee, they may choose not to resign for fear of being out of work. So does that mean it's a risk that could be worth taking in some circumstances?
I think those circumstances would be very rare indeed. I mean, at best, it would create a lot of uncertainty. Effectively, what the employer would need to do is impose the change and then seek to show at a later stage that the employee had somehow impliedly consented by continuing to work under the new terms. Even if the employee does not resign, he or she can still make it clear that they are working under protest, reserve the right to bring a claim for any financial losses at a later date, so perhaps when they found another job and feel ready to leave.
And there are perhaps wider ramifications, I think, in terms of staff morale.
Almost certainly, a heavy-handed approach by an employer can really damage workplace culture. So I think the message here is, if you do not have the right to make changes under the contract, consult with the employee and seek their consent. If you can't persuade them of the business need for your proposal, consider whether it is absolutely essential, and only then move to dismiss and re-engage.
Right, so let's talk a bit more about dismissing and re-engaging. It's something that's mentioned a lot, but in practice and in my experience, it's rarely used.
Yes, I'd agree with that, Scott. And normally we would only advise it where there are compelling business reasons that have been clearly explained to the employee during a full consultation process. So the employer is saying, look, we've tried our best to get you to agree, but we really have to make these changes for X, Y, Z reasons. They are business critical. So the employer then terminates the existing employment contract by providing the required notice or payment in lieu if that's permitted, and hands the employee a new contract containing the new terms.
And that would be a dismissal. So how does that tie in with unfair dismissal?
Well, the same two-stage test applies as for other types of dismissal, Scott. So first, you need to look at whether there's a potentially fair reason to dismiss recognised by law. So here it's not a question of an employee who's guilty of misconduct or poor performance, for example. However, if there are very good business reasons which are well documented, they can potentially fall within the category of some other substantial reason for dismissal, what we call a SOSRA dismissal.
And I guess the second question is, has a fair process been followed?
That's right. So was the decision to dismiss within the band of reasonable responses open to the employer in the circumstances? And largely in these cases, it's about the quality of the consultation process. Has the employee had an opportunity to explain their objections, and have those been properly considered? Also, is this employee a lone voice in objecting, i.e. has everyone else agreed to the change? So those are all those types of relevant factors.
And you mentioned that there may be circumstances where changes are proposed that affect a whole group of employees, maybe even the whole workforce. So what are the additional requirements here?
Yes, so if there is a proposal to dismiss and re-engage 20 or more employees within a 90-day period, then those collective consultation rules, which normally apply to larger scale redundancies, are also relevant here and must be complied with. So the starting point, as you might expect, is the employment contract. An employee has a duty to obey reasonable and lawful instructions, and what is reasonable and lawful will depend on what the contract allows you to do.
Exactly, and it goes without saying, I think, that you need to look at the terms of the contract very carefully.
Yes, Scott. I mean, for example, if you want to change an employee's duties, does the contract give you express authority to do that? And if it does, are there any limits? So I've seen plenty of contracts which say that yes, the employer can ask the employee to do things that fall outside their normal job description, but only if they act reasonably or act in accordance with business requirements, or, for example, after consultation with the employee. It may not be an unqualified power.
Yes, so we're saying that imposing changes unilaterally can be done as long as the wording in the contract is clear. The contract is king.
Yes, certainly as far as the law is concerned, but I think there are two notes of caution here. First, although you are right that the contract is king, the contract also includes an implied duty of mutual trust and confidence, and this is a fundamental term implied by law into every employment contract.
And what does that term say?
Well, it says that neither party must, without reasonable and proper cause, conduct itself in a manner calculated or likely to destroy or seriously damage the relationship of trust and confidence between the employer and the employee.
Wow, that's a bit of a mouthful.
Well, it is, I agree. To give some context, let's say that the employment contract gives an employer wide powers to make changes to the employee's duties. Mutual trust and confidence set some boundaries. If what the employer is asking effectively amounts to a demotion or a loss of status, it might be allowed on a strict reading of the contract, but the trust and confidence duty says, hang on a minute, there's a problem here. So if we give, for example, perhaps a slightly extreme example here, Scott. So you're removing a CEO from his strategic figurehead role within the organisation, and instead you're going to give him a list of kind of low-skilled admin tasks. Would that destroy or seriously damage trust and confidence? Quite probably, if it goes to the core of the employment relationship. Is it calculated or likely to do so? Yes, almost certainly. Is there a reasonable and proper cause for it? I think you need a pretty compelling reason to demote a CEO in that fashion.
Yeah, so I think it's fair to say that mutual trust and confidence is very important.
Absolutely, but what is being proposed must be sufficiently bad to destroy or seriously damage the relationship, to the point where the employee can no longer be expected to stay if the change is forced through. We're talking constructive dismissal territory here.
Sure, and I think you mentioned a second point as well.
Yes, so this is more of a practical issue, I think, Scott. In reality, where the employment contract allows you, for example, to change an employee's duties, much will depend on how the issue is broached with employees. So there is a balance to be struck here. If it is a minor change or one which is likely to be uncontroversial, an informal chat or straightforward message that the employee will be asked to cover alternative duties will normally be sufficient. The contract allows you to do it, you've told the employee, and that's that. But the way in which it is messaged is quite key, and this is really where HR can be really invaluable in helping managers with those softer skills.
And what about for more significant changes?
Well, again, the contract may allow you to do it, but it is worth considering whether a period of consultation is appropriate to allow employees to air their views properly. It is a bit of a judgment call, but the approach is likely to be dictated by how significant the change is in reality and its likely reaction to it. So obviously it's not practical to consult on everything, otherwise nothing would get done.
Yes, and I think it's probably worth thinking about it from the employee's perspective as well. So to the employer, changing a line manager or a job title may not be a major issue, but it could well be a big deal for an employee.
Yeah, that's a very good point, Scott. And there are potentially sensitive issues, particularly if they could upset the team dynamic or the employee perceives that they are somehow being demoted, even if that's not the case.
So perhaps we should briefly cover another specific example. So in my experience, the issue of mobility clauses comes up all the time.
Yeah, that's definitely worth mentioning, Scott. And by mobility clauses, you mean something in the contract which allows the employer to relocate an employee to a different office, for example.
Yes, in many respects the issues are the same. It's all about precision of the drafting. When you come to put a mobility clause into a contract, it's sometimes difficult, of course, to know when and where you're likely to need to move employees in the future, though.
Yes, and as we've discussed, there is a balance to be struck here between enforceability and flexibility.
That's right. So having the right to require the employee to work at any other location in the world is unlikely to be helpful in practice. Although on the face of it, it gives maximum flexibility, you're going to struggle to present a convincing argument that an employee would genuinely have expected that they could be moved to Australia without the right to object.
Sure, and that would definitely engage that implied duty of mutual trust and confidence. So you need some parameters, effectively.
Yes, again, it's a slightly extreme example. A better clause would define a reasonable location or distance within which you can require an employee to move, perhaps to another office within reasonable commuting distance, for example. And context is still important. It doesn't matter how good your mobility clause is, if you use it to try and force through an unreasonable change, it's just not going to work.
Is this something that the courts have considered at all, Scott?
Yeah, certainly. So there are quite a few cases on this, and I think the leading one is United Bank and Akhtar, and this illustrates the point quite well. So here, Mr. Akhtar's employment contract contained an express mobility clause allowing the bank to relocate him. However, the bank told him one Friday that they wanted him to relocate from the Leeds branch to the Birmingham branch, and demanded that he turn up for work in Birmingham on the following Monday. He asked quite reasonably for a short postponement to consider it and make any necessary arrangements, but this, probably unreasonably, was refused. In that context, where the employee was given absolutely no notice, a request for postponement was refused, and he was given no financial assistance to move, Mr. Akhtar could resign and claim constructive dismissal, and this was despite an express term that appeared to cover the situation.
Okay, that's clear, but are there any circumstances in which the contract does not give the employer an express power to make a change in duties, job location, etc., but where there might be an implied right to do so?
Yes, to an extent. So if the contract is silent, it is much more difficult. Generally, terms will only be implied into employment contracts in narrow circumstances. An implied term must be necessary to make the whole contract work, or so obvious that it goes without saying. So normally any implied terms are based on established custom and practice, but that is a risky basis on which to try to introduce a change.
Yeah, and I think it's also worth noting that many employment contracts contain a clause saying that the written terms represent the entire agreement between the parties, which makes it even more difficult to imply additional terms. Well, that's almost it for this month, Scott, but before we go, I should mention one topic that we've not really had time to discuss in detail. Many contracts contain room for the employer to exercise its discretion, so most commonly in relation to calculating bonuses, but also in other areas such as the withdrawal of benefits. It's probably a subject that's worthy of a podcast in its own right, but in the meantime, I wonder whether we could perhaps give some very high-level bullet points on how employers should approach the exercise of discretion.
Sure, this is a pretty tricky area, but there are some fundamental principles that employers should bear in mind. First, where possible, the contract should define precisely the parameters of discretion. So what exactly is it that the employer must decide? For example, is it whether an employee receives a bonus at all, or is it how it's calculated, or is it in what circumstances a bonus might be capped?
Yeah, I think that's very important actually.
And I think if you can do that, it puts you as an employer in a much stronger position. Courts are certainly reluctant to interfere in discretionary decision making. So as long as it's not an irrational or perverse decision, that is one which no reasonable employer could have come to, it's hard for an employee to challenge.
Yeah, I'd agree with that. And I think the Court of Appeal once famously said that it would not interfere with a bank's decision on what bonus should be paid to a senior employee, simply because it said the court is not a bank. And it also said that there would need to be an overwhelming case to demonstrate that kind of irrationality you were talking about. However, I do think that an employer needs to take care to demonstrate that the decision-making process it has followed is fair, so to show what factors it has taken into account in reaching its decision.
And it also helps to tell the employee the reasons for the decision, I think.
Yeah, absolutely, yes. Okay, well, that's been a really useful overview, and it's been really good to discuss these issues with you, Scott. If our listeners want to get hold of you to discuss them in more detail, could you remind them how to do that?
Of course, all of our contact details are available by searching for us on the Taylor Vinters website, www.taylorvinters.com, and you can reach me on email, scott.glacken@taylorvinters.com, or via LinkedIn.
Great, thanks Scott. And next month I'll be looking back at some of the highlights of 2015 in our HR ListenIn review of the year. It's been a really interesting 12 months, so I'll be giving a short reminder of some of the key issues we've covered in this first year of the podcast. In the meantime, you can access all previous editions of this podcast by clicking on the ListenIn icon on our homepage, where there are direct links to the web pages of all presenters. For those of you who are active on social media, you can also find me on LinkedIn and on Twitter @DomHolmes147. Thank you for listening in to HR ListenIn.